the Christian South and the Muslim North, that also needs to be addressed in the Constitution. I'll just mention a case to illustrate the point about, and this relates to discrimination against women, which is one of the fulcrums of development covered by both the MDG goals and the SDG goals. Equality of women, which is the fifth goal of the Sustainable Development Grounds. Now, the case of Amina Lawal versus the state comes into focus. This was a case which challenged the notion of equality of women. If I can just briefly highlight the facts, even though the outcome of the case was satisfactory, it threw up a residual prospective challenge to the supremacy of the Constitution vis-a-vis Sharia law, now applicable in 12 states of the Federation. Now, what was interesting in this particular case and why I highlight it was counsel for the convicted appellant contended that the accused should not have been convicted under the provisions of the Penal Code, as the commencement date of the law showed that the infringing conduct took place 6 months before the applicable law was passed. Now, that's a basic constitutional principle. However, counsel for the state effectively argued that the Islamic penal system law provided that judgment should be based on the Quran and the Sunnah and not on the 1999 Constitution that was cited on the accused's behalf. Fortunately, the court allowed the appeal, but on other grounds, and did not discuss this issue, which remains moot, even though in several other cases, there have been conflicts between laws under the Islamic code and the Constitution, and the courts have upheld the Constitution. But this is just to illustrate some very fundamental issues that 60 years after independence, Nigeria is still grappling with and must confront and put into perspective. The time allocated for this presentation doesn't really allow one to give too many examples. So suffice it to highlight the fact that across conflict-affected countries such as Nigeria, crime and violence are cited as amongst the top constraints to productivity and growth. Therefore, it seems reasonable that strengthening the armed forces, the police, the criminal justice institutions towards improving security and law and order, including attending to the needs of victims of crime, must be amongst the most urgent priorities for us to enable development. Other impediments to the rule of law in development include the untold delay that we've always talked about in the administration of justice itself, which can only be improved by a review of the rules of practice and procedure to further eliminate bottlenecks in the tunnel of cases and controversies that come before our courts, including innovative procedural reform. Strengthening accountability and legal checks on power, and of course, zero tolerance for corruption, nepotism, and rent seeking, which affects costs of economic actors through legislation-driven institutional checks on public and private accountability. I think this would clearly promote a fairer allocation of services through credible mechanisms that will shape the provision of public services and the quality of public infrastructure by promoting investment and economic growth. The rule of law cuts across development endeavors, from road building to port building to the provision of basic infrastructure, electricity. How over $30 billion could have been spent on less than 3,000 megawatts of electricity, and how the quantum of consumption of petroleum products would suddenly double, or the amount spent on the wasteful subsidy of petroleum products could double or triple in a particular period, are all matters of rule of law. They're not seen like that. They're seen as sectoral issues. But at the end of the day, if the rule of law is strengthened, then some of these challenges will be addressed, and resources that are being wasted can be used towards development.
Thank you very much.
A legal system that fails to confront such glaring contradictions cannot serve a nation's development aspirations or outcomes. I think that the whistleblowing policy is therefore a step in the right direction. However, comprehensive whistleblowing legislation is probably still required to give teeth to the policy. The rule of law is also important to any notion of sustainable development in protecting our environment and natural resources. Here, I would single out continued gas flaring as a particularly egregious infringement of environmental laws and regulations that fail to protect or advance the right of people to health and to a balanced and healthy ecology and economic rights in the Niger Delta in particular. These examples that I've given are obviously not exhaustive, but give an insight into the possibilities as we step forward under the theme of the rule of law on the 60th year of the NBA.
Thank you.
Let me therefore just simply conclude my introductory remarks by saying that the rule of law applies in a complex, multi-dimensional space of political and social change that's tied to governance reform, and that requires some innovative rethinking of what the rule of law is and what it must be made to be for development to be enhanced. I'm sure that at the end of the other presentations, there will be specific questions that have arisen from my brief remarks, and I look forward to a healthy discussion on the subject. Thank you very much.
Thank you very much, Mr. Jumagobia. That has been very helpful because you've taken the conversation forward. You've raised some very critical issues. But I will not begin to speak to those issues or take any questions immediately because we need to take our colleague, that is Professor Lumumba from Kenya. I understand that right now at Kenya there is a curfew, which implies that he has to come through very soon and so he can get home in good time. I am very sure that Professor Lumumba will be able to show us how the fact of the curfew itself, which is probably an issue around security and safety, how the rule of law is implicated in that. It'll be really insightful to get a sense of that. But like I said earlier, he is one speaker that is known to speak truth to power, and I'm really excited that he's able to join us. Professor Lumumba, please share your thoughts with us on the rule of law, where we are in that regard in Africa. Is there an African context to the rule of law? Does it need any adaptation? Is the model that we seem to have borrowed from the West, from England in particular, is it sustainable, or is there something else that we should be doing? Thank you very much. You have just about 15 minutes. Professor Lumumba, can you check that you're not muted? Can you check that you're not muted? You're not. The sound isn't coming through. We can't hear you. Can you check your audio? Can you just check your audio? Okay, maybe you can start now. Let's see. It's still not coming through. It's still not coming through. Prof, is there anyone who might be able to just check that your system? We can't hear anything at all. Okay, so while we're trying to have that sorted out, I will just invite Mrs. Aisha Oyebode to share with us her perspectives. She particularly indicated that she thinks that she has perspectives on how lawyers should move the rule of law discourse forward, as well as the rule of law aspiration. So, Mrs. Aisha Oyebode, can you please just share with us?
Okay, so good evening, everyone.
Okay.
Can you hear me?
Yes, we can hear you, but we need volume.
Can you hear me better now? Is it louder?
Very well now.
Now I can't hear you anymore. So I think it might be the network or something. Oh dear. Okay, so basically what I wanted to talk about with regards to the rule of law is usually when we talk about it, we tend to talk about the fundamental principles, we talk about liberalism, we talk about democracy, we talk about the principles of the separation of powers and legality, recognition of individual freedom and equality, judicial review, law and morality. Those are, so we tend to look at it in terms of lofty, overarching goals, which are important. But I think sometimes it's important to bring the rule of law down closer to what it is that we can relate to. So I'm a member of the senior working group on Nigeria that advises the United States Institute of Peace. And one of the partner programs that the United States Institute of Peace has is with the World Justice Project. And it's on the rule of law. And basically is to see the ways in which we can measure the rule of law. And that, in fact, has actually been touched upon. Oh dear. Can you still see me?
We can see you. Okay. I think she is frozen. Do we still have Professor Lumumba on? I think Professor Lumumba himself is gone off. Okay. Well, maybe what we'll do is maybe we take what we'll do then is we break the session into two, and maybe we take some questions directed at the speakers who are still on, and hopefully other speakers will get a chance to come on, and then we can listen to them and then direct some questions at them. Okay, you are back? Yes. But you're muted.
Where I stopped, so I might have repeat a little bit of what I said earlier. So what I'm talking about is how I started talking about the World Justice Project as part of the partnership with the United States Institute of Peace, of which I advise as a member of their senior working group on Nigeria. Now, what's really important about the World Justice Project is that it gives you indices which you use to now measure the rule of law. So it gives you more sort of like tangible things with which you can say, okay, you know, these are the things that we can do differently that can affect the rule of law. So, but before I start talking about the indices, the first question, which is one of the questions that they try and answer with the World Justice Project, is the issue of why is it important? Why should it matter? You know, and I think both Mr. Spears and Mr. Ajumagobi had actually mentioned it when they talked about fragility. If you're in a state that has fragility and you have no rule of law, then it means that that's a recipe for violence and extremism. And we're seeing that in Nigeria right now. We've seen that with Boko Haram insurgency. We've seen that with the agitations in the Niger Delta. We're seeing kidnappings, including of the Chibok girls. We're seeing a lot of extrajudicial killings where, you know, recently, about a month ago, there were, actually, it's a bit longer than a month ago, a couple of, maybe 2 months ago in Katsina. And, you know, part of it is the brutality that we also see of the killings when babies were being thrown into live fires in front of their mothers. You know, there's the Fulani herder conflict, the herder farmer conflict. You know, so so there's that whole issue around fragility and insecurity. That's one of the issues. The other issue, which Mr. Ajumagobi had touched on a little bit, but I just would like to talk about it a little bit more, is that when you do have effective rule of law, as is being measured by the index, it reduces corruption, it combats poverty and disease, it protects people from injustices. And more importantly, it's seen as the foundation of communities of justice, an opportunity for peace, underpinning development, accountable government, and respect for fundamental human rights. So it matters because we will see growth in the economy, as Mr. Ajumagobi has said, we will see socio-political development and even human development. If we have rule of law, our GDP will be higher, and we'll have you know, better democracy, peace, better education, and health outcomes. So how then do we then measure the rule of law? Brian Spears had talked about the 4 universal principles. I'd like to repeat them. So there's accountability. And so that talks about the government as well as private actors are accountable under the law. There are just laws. The laws need to be clear. They need to be publicized. They need to be stable. They need to be applied evenly. And they need to protect fundamental human rights, including the security of persons and contract property and human rights. Then there's open government, the processes by which the laws are enacted, the way in which they are administered, enforced, the way in which they must, you know, enforcement must be accessible, it must be fair, and it must be efficient. And of course, accessible justice. Justice must be delivered in a timely, competent, ethical, independent manner, you know, by representatives who are neutral and who are accessible again and have adequate resources and reflect the makeup of the communities in which they serve. So these are the 4 universal principles. Now, beyond the 4 universal principles, they talk about 9 other factors which make up the rule of law index. And I'm going to try and see if I can just share my screen. I hope that's okay. Okay. So these are the way in which the indices, the rule of law index measures, whether or not countries are complying with the rule of law. As is usual, Nigeria ranks towards the bottom of the index. Overall index, Nigeria is 108 in a total of 128 countries. That's not good. But more importantly, if you go down the 9 factors and you start to look at constraints on government powers, okay, so Nigeria ranks probably, we would say, 68. Absence of corruption, we rank, I believe, in fact, we rank 109 on the absence of corruption. I think we've done much better on open governance. We're now at 94. Fundamental rights, 99. Order and security, we're 127. We are the second to the last country before Afghanistan. Regulatory enforcement, we are 99. Civil justice, we are 75. But the one I really want to talk about is criminal justice. Even though we appear to be at 76 in 128 countries, if you look at our criminal justice indices in respect to where we are, even in relation to the rest of the African continent, we rank pretty low. And I feel that that's one area, where I think that lawyers really need to be thinking about. So I'm not just looking at it from the macro or the meso level. I want to bring it down to the micro level. I think that that's where we need to begin to say, what is it that we can do differently? We are the guardians of the law. How is it that we can do things differently that will impact the criminal justice system? Because I feel that, so we've got all these 9 factors that make up the rule of law, but at the same time, I feel that there are some that are clearly very, very distinct. And I'll share a personal story very quickly and then tell you why the personal story is relevant. In 1993, my younger brother, the one who is immediately after me, was shot at point blank range by a friend of his, and he was killed. And the matter went before the young man was arraigned. And then because his father was a prominent politician at that time, the matter it just disappeared. All the documents and everything disappeared from the courts. For 5 years, we petitioned the Office of the Attorney General to see if anything could be done about it. Until today, nothing has happened. But you see, my brother is just one in the thousands of Nigerians. And I'm sure many of you would remember prominent Nigerians like Dele Giwa, Alfred Rwani. Bola Ige at that time was Attorney General and Minister for Justice. He used to be former governor of Oyo State. The shock killed his wife at Ike Ige and left his children orphans. Funshaw William, Kudirat Abiola, Ayodai Ramola. Even last week, we were talking about Chidinma Ajoku, and Chima Iwaipe was in the news. A container fell on them on their way to work. Chidinma was 27, Chima was 29. Just recently, Hajara Ismail is a woman who in Bauchi was, her son was brought to her in the back of a police truck because he had stolen chickens from a former policeman who had, a former police, I think he was a police boss. Anyway, the long and short of it is that I think that if we as lawyers, after so many years, are still not able to deal with the impunity in the criminal justice system, then I really wonder whether, we can then hold ourselves up and talk about all the other elements that make up the rule of law. Our criminal investigation system is ineffective. I'm actually going back to the soft factors that we use as a rule of law, that the World Justice Program uses as an index for measuring, our effectiveness in terms of criminal justice. So criminal justice investigation system is not effective. Criminal education system is not timely, nor is it effective. Our correctional system is not effective in reducing criminal behavior. Criminal justice system is definitely not impartial. We now see that our police think that they are judge, they are jury, they can be executioner. It's certainly not free of corruption, and criminal justice system is not free of improper government influence as well, and due process of law and rights of the accused are definitely not permanent. So that brings us to the culture of impunity. Once our criminal justice system is failing, it's clear that what we are now seeing that seems so normal is that we have now developed the culture of impunity. But unfortunately for us, we are still not able to relate that impunity to what it is that we think we do on a daily basis. We see impunity as something that somebody else is doing. We other, A-O-T-H-E-R, we other responsibility for impunity. We think it's somebody else's responsibility. So we do not concern ourselves with the fact that the police are improperly trained. We do not concern ourselves with the fact that the police think that they are actually minions to government officials and those who rank high in society. All of those are things that we see as separate from us. But these are the things that determine whether or not we have a criminal justice system that is effective. Now, so if we then say to ourselves, okay, let's leave the criminal justice system aside. If you look at all of the other factors, I have them listed here. If you talk about the constraints of government power, the sub-factors, and I won't go through all of them, is, so there's 6, of which 5 out of the 6 are actually, again, within the control of us as lawyers. Government powers are effectively limited by the judiciary. Government powers are effectively limited by independent auditing and review. That's what is measured. Government officials are sanctioned for misconduct. Government powers are subject to non-governmental checks. Transition of power is subject to the law. It's the same with regards to the absence of corruption. It's the same with regards to open government, fundamental rights, order and security, regulatory enforcement. We've done well with regards to civil justice. We've actually gone up on the index, so which means that people are getting better access and affordable civil justice. And some elements of it are becoming freer of discrimination. Civil justice, well, it's not as free of corruption as probably it should be, but at least relative to the criminal justice system, it's believed that civil justice system is free of corruption. It's also freer of improper government influence, is not subject to unforeseeable delays. The delays are now being minimized, and it is arguable, but it's thought that civil justice is effectively enforced, and also alternative dispute resolution. And I think that's probably why our indices have gone up, is because alternative dispute resolution has become more accessible, has become more impartial, and has also become more effective.
Has she gone off? Okay. Well, one of the challenges of the IT world, the speaker seems to have dropped off. Maybe she will come on. But while we're waiting for her to come on so that we do not take too much time waiting, and I just have a couple of questions for the first two speakers, and we'll see whether Mrs. Oyebode is able to come on, and then we can take off from where she stopped and then still add some questions later. Mr. Spears, when we talk about the Commonwealth, we're talking of countries that span, various cultures. In your experience, I know that the Commonwealth has tried to come up with basic standards, that is generally accepted. But would you say that the rule of law permits in any wise of any perspectives that is rooted in society's culture, its history, its politics? Basically, I'm asking, can we have different types of rule of law? Can we have different? You must have encountered some of these arguments. How have you confronted them? How have you responded?
I have mentioned in my opening remarks that, so far as I personally am concerned, there are elements of the rule of law that are immutable, unchangeable, whether in the Caribbean or the Pacific. That the fairness of the system, how laws are made, the independence of judges, and the fair application of law to everyone is, I think, just non-negotiable. What I have encountered are changes that are influenced by ethnicity and religion. And these are areas that somehow have become difficult to discuss without being accused to be either intolerant or racist or in some way have a prejudice. But the fact of the matter is, in my report on child marriage across the Commonwealth, what I discovered, or what the Commonwealth Lawyers Association discovered, was that across all of the now 54 countries in the Commonwealth, there are laws. There are adherences to international conventions that say the marriage of a girl child as a child should not take place. It is against the law. And yet, many countries have experience of precisely this event happening. And it is justified on the basis of either customary or traditional practice or law or religion. And this seems to me to be trying to place an individual or sector-specific or religious-specific context on the rule of law that simply should not be acknowledged or accepted. So from my point of view, there are immutable, unchangeable norms that should apply. There are, of course, individual areas within this very broad reach of a subject that will result in different laws in different countries. And provided that they are brought about by a rule of law compliant process, there is, of course, nothing wrong with different countries having different laws. In the United Kingdom at present, it is surprising perhaps, but there are different COVID-related laws as to the wearing of masks, as to the age at which protective face covering should be worn, as to the return of children to schools, as to local lockdowns that are different in Belfast and in Edinburgh, and are different in Edinburgh to Cardiff, and different in Cardiff to London. So if laws are made appropriately, then changes in what the law means and as it's experienced can be acknowledged. But the underlying principle is, how are laws made? Are they made by a properly elected and fairly elected government? Are the laws scrutinized by an independent parliament? And are the application of the laws carried out by officials who are acting reasonably and not exceeding their powers? And are lawyers entitled to constrain and challenge the application of laws? So my thinking is that there are immutable aspects, but there will be individual changes according to each country passing legislation applicable to its individual circumstances. Maybe that will kickstart a conversation, Professor.
Thank you very much. Yes, I think it should kickstart a conversation, and I am actually just going to do that.
I seem to be the only one unmuted.
No, Mr.
I see Mrs. Oyebode. Are you going to come in?
I think she's come.
I'm back, but unfortunately, I didn't hear the question. So if I can hear the question again, I'll speak on it. I didn't hear the question.
Okay.
It was about whether the rule of law changes according to context in which you are in. And therefore, my answer was saying, I don't think so, but individual countries might make individual laws differently.
Yeah.
I agree with you totally. I think the standard the basic immutable standards that the rule of law, wherever it is you make laws, must apply. And that will not change, shouldn't change irrespective of which country you're in. And I think that's actually the whole basis of us trying to have a universal standard for the rule of law, so that, we can then, and being able to measure it also allows us to see those that are falling beneath it and those that, beneath that standard. So there are various basic principles, the issue around safeguards for everyone, accountability, clarity, evenness of application, and then even the process for administering and enforcing laws, and most importantly, justice must be impartial and accessible. I think that's important. Yes.
Okay.
I wonder, without taking over the moderator's role, does Mr. Ajumogobia have a thought on this interesting?
Yes, I think I'll be a little contrarian here. I think we obviously inherited. Our inheritance was British common law, statutes of general application. We've developed our own laws since independence, and therefore the Anglo-Saxon model has been to focus on individual rights, the protection of individual rights. And so when we talk about access to justice, we talk about equal protection of the law. It's about the individual. It's all about the individual. Government is to provide welfare and security for the individual. The individual has rights to challenge things that happen in society, et cetera, et cetera. Now, there are really two models, if you like, with regard to good governance, which is what we're really talking about, the rule of law that promotes good governance, promotes development. And I like to think about China as an example. Nobody would instinctively, when you think about China, you don't think about the rule of law, because the focus is on the development of the state at the expense of the individual. But there's no question that China has scrupulously enforced laws. They have, their development has been enabled by the rule of law. Now, it's then therefore becomes a matter of definition, whether the limitation on rights of the individual that is clearly constrained in countries that don't practice democracy in the way that we do, or we try to do. But if we're talking about, in the context of my comment, my earlier remarks, that I think what we're lacking in a lot of developing countries, and on the continent especially, is the lack of enforcement of law. It's not the existence of law, it's a lack of enforcement. And if you can enforce laws and therefore the environment is predictable, then you will have the sort of development trajectory that China has experienced.
Well, maybe the question I will then be asked.
Yes, that's very interesting in the sense one of the conversations that I have had recently revolves around Hong Kong, which is a Commonwealth jurisdiction where Chinese law has been passed in the manner that Chinese law normally passed, and now applies to a jurisdiction which had, of course, an experience of the type of rule of law, individual entitlements that you have just described. So that is certainly a source of tension. But what you're maybe asking is it the law that is changeable and the adherence to the law is not changeable, but that our laws are crafted in different ways for a different purpose? And I do think this clash between China and Hong Kong at present is a really interesting but pretty treacherous challenge. You'd also.
Can I come in? Oh, okay, sorry.
Can you hear
go
me?
ahead. Sorry.
You can
of course come in, Mrs. Oyebode, but I was going to then slightly expand the discussion into compliance, because we have a great deal of treaties and declarations. And I've referenced the Latimer House Principles signed in Abuja itself by all the Commonwealth heads of government. And so one might think that the Commonwealth countries would be high, soaring on the rule of law index, because they have, in theory, signed up to the rule of law principles as we understand them. But sadly, so many Commonwealth countries are not yet soaring up the table. And therefore, to me, it becomes not just an institutional and government state approach. Individuals must change, hearts and minds must change. And this message that Mr. Ajumo-Gobea has got out about the benefits for commerce is really vital to continue to emphasize, because we are not going to achieve prosperity, fairness, equality, and adherence to the rule of law simply by signing up to treaties and declarations. We need to comply with them.
Can the speakers hear me?
Mrs. Oyebode.
Yes, no, I wanted to go back a little bit about the conflicts when we're talking about rule of law in countries like China, and when we compare it to standards that we think are the standards that we are used to. But in real terms, so I can bring it back home here. There's always that, argument about, is it rule of law we want or rule by law, which means that, the fact that you make these draconian laws and you can enforce them, is that what the standard that we want? And if you look at even, for example, take the Boko Haram insurgency, where they demarcated territory and they claim to apply their laws. And some of these laws are pretty brutal, and they're pretty vicious, and they don't conform with any standards of law as we know it. So I start to worry about, where do we then draw the line for that kind of situation? Because then there's a risk. And if we don't, if they're universal standards, and those universal standards are I'm looking at Research Magobia, and those universal standards can be altered, then I worry.
Okay. I believe the speakers.
So I don't know whether.
Okay. Thank you
Thank
very much, guest speakers. I think thank you for the conversation. Thanks for taking it and making it smooth. But I'd just like to zero into something, which is we've talked about the ideals. The challenge is, so what makes for, we just need to enforce. So why have we not been able to enforce? What is the problem? I know that Mrs. Oyebode was alluding to that when she was speaking about the legal profession and how we seem to be very critical players in the areas where we have the lowest score on the index. So the question is not just the issue is not just to be able to identify the challenges, but to ask ourselves, it's about stepping forward. So how are we going to move forward? And that reminds me of the case study presented by Mr. Ajumogobia, when he said, when you have a challenge to the Constitution itself, which law then are you living by? Which law is ruling? But you know, it's not just it's not definitely not good enough for us. And this time I'm directing my questions to the Nigerian lawyers on this panel. How do we go forward? What practical steps? I have seen the questions. People have asked about executive lawlessness. And the question is, how do we break it? How do we just stop what seems to be the norm so that we're able to move forward? So I will start with Mr. Jumogobia and then I'll come back to you so that we will really be able to go forward. We've identified the problems, we've identified the challenges, but the issue is, so we know us, we know what the challenges are. How do we step forward, especially as lawyers, as a bar association?
Can I start? Let me, for the avoidance of doubt, make clear, advocating that we adopt the Chinese model, that I do believe that the rule of law and protection of individual liberties are essential, ultimately, for sustainable development in every nation. And I'm a firm believer that even if you look at, I gave the example of China, but even if you look at China, individual liberties are slowly growing. I mean, the number of Chinese who travel abroad every year and go back, it wasn't always like that. And I think that it's probably a time. Having said that, I think the answer to that, my answer to that is institutions. We need to strengthen institutions. The set of institutions that I would highlight, and also referring to, this relates to what Mrs. Oyebode said about where do you draw the line? I mean, we are impliedly talking about the rule of good law, whatever that is. I mean, if you go back to the philosophical underpinnings of the rule of law, the debate gets very interesting because you had, apartheid in South Africa, where laws were enforced, but most people would agree that those laws did not meet the essential criteria of being good law. Now, the institutions are obviously the government itself, the executive, the presidency, of the governors and MDAs, the police and law enforcement agencies, and agencies, the electoral commission. How's leadership selected? What's the process? How do we ensure that we don't have, as the vice president said in his remarks yesterday, you're not in court for 3 years, challenge 4-year term, deprived of. The media, we had, there were noises about passing a social media bill to try and restrict activity in social media. The central bank, I mean, these are the institutions that I think are the core of our development, where they must be insulated from interference. The laws must protect their objectives and ensure that they're not manipulated by people who would wish to abuse their offices. And of course, in a context of a dearth of security or insecurity, the armed forces, strengthening the armed forces, equipping them, and ensuring that the basic security, which is what creates stability for all these other institutions to be able to function effectively. And I think in Nigeria, we really face the challenge of addressing all of these at the same time.
To Mrs. Oyebode, and I'm just going to ask the same question, but I am going to tie it around something else, which is private capture. You know, the private capture of the state. You know, you talk about the rule of law, and it promises a lot, and but you suddenly find that you're dealing with the private capture. I know that Mr. Spears did go on to talk, say the laws must be well made, they must be made by the right institutions, they must follow the process, and then we have also the issue of corruption. What linkages, how do we ensure that we do not have, that the rule of law does not get manipulated and subverted when you have capture of the state and corruption, because this time we're trying to shape the agenda.
So was that, I'm sorry, I heard half of the question.
Okay.
I'll piece it together and add it to what Mr. Ajimobobia was talking about earlier and, you know, answer it. And if I'm not going the right way, you can bring me back. So I think the problem we have, and the only way we're going to go forward, is that we have to have zero tolerance for impunity. We have an entrenched culture of impunity that has made so there are no consequences for actions. I talked about murders. It seems as if I talk about that a lot. But if there's a breach of your most fundamental human right, is when you take someone's life. People are killed and there are no consequences. Threats, attacks, you know, all of that. And whether the crimes are economic or financial, when you break the law, when you abuse the law, when there is a zero, there's a total culture of impunity. So the first thing is, I think we need to develop a zero tolerance for impunity. I think that's the first thing, because it's already been said earlier that the issue is not that we do not have laws. The issue is that the laws are not being enforced. And I believe you me, if we start to have a zero tolerance policy on impunity, a lot of things, all of those 4 principles, the 9 objectives I talked about will all start to fall in place. Just think about it when you have a quiet moment and you think, if there's total and absolute proper application of the rule of law, what kind of country would we see? The other issue is a culture of personal responsibility. I'd mentioned it earlier. It even has to do with corruption. You know, we think corruption is something that is lurking out there in the background and has nothing to do with me or us or anybody else. It's the same thing with everything else that is important with regards to how we uphold the law. We think it happens to somebody else. We think it's okay if that policeman allows us to drive down the one-way road because we're in a rush to go somewhere. We think it's okay for policemen to stand outside and guard our parties, you know, all of the things that each and every one of us is responsible for. There has to be personal responsibility and accountability. I need to be able to say, this thing is wrong. and I will not do it. It's very difficult because, again, we have, it's become entrenched. But my view is that there's no culture of impunity that is invincible, no matter how entrenched. So those are my answers to questions.
We're gradually coming to the end of our symposium. I think it's really important for us to begin to sum up now. Clearly, from what the speakers have said, we have immutable principles or elements of the rule of law. Whereas the rule of law has capacity to accommodate contextual variations, maybe because of the differences in people's culture, but there are certain aspects that are non-negotiable and should never be varied. But it would appear that there are quite a number of things beyond law's reach. And yes, I always say to my students, there's a limit to what law can do. Law is not self-enforcing. Law assumes, or law has to be enforced by people who believe in it and and that's what the last two speakers have spoken to. But I would say that what we need to do is start small and start with ourselves. The question is, how disciplined has the legal profession itself been? The indices that were read out to us concerning the criminal justice system, where we are key players, suggests that we play a very significant role in manipulating the system and occasioning all the complications that seem to make us score extremely low on that level. Now you can imagine that if we score that low, little wonder that the citizenry have no confidence in the criminal justice system. And when you consider that for the citizenry, in their mind's eye, the criminal justice system symbolizes the whole of the justice system. So when they have such low esteem, low confidence in the criminal justice system, it's little wonder that their attitude to law and justice is basically, we do not have the public confidence to support that we need to give strength to the justice system. I dare say then that the agenda is cut out for us. The agenda is cut out for the incoming executive. The bottom line is that we need to start with ourselves. Maybe we need to look at how prepared are we to enforce even our own internal laws against our own acts of indiscipline, our own whatever. And hopefully when we begin to start that way, we will begin to circumscribe what's acceptable, the impunity that characterizes the society. So at this point in time, I just want to say a very, very big thank you to our speakers. Thank you for the conversation. Thank you for helping us understand that we can't ever close the chapter on what we know about the rule of law. It's always there. It's something we continue to engage with, and I believe that it's really necessary for us to push forward. Even the conversation that we've started to have today, unfortunately, with a lot of IT disruptions, we didn't get the best, especially because we lost one of our main speakers that we were looking forward to. And so I will urge that at the earliest opportunity, some group of us, maybe the broad MBA platform, maybe some section of the MBA, maybe the academia, we definitely must look for another opportunity to reopen this discussion, reopen this conversation, so that we at that meeting are better able to identify the key things that we need to do to take the issues forward, to address some of the problems and the factors that we have identified. I can't say enough thank you to you, my stellar panelists. Thank you very much, Brian Spears. Thank you very much, Mr. Odena Jumogobia, SAN. Thank you very much, Mrs. Aisha Oyebode, and of course a very big thank you to Professor Patrick Lumumba, even though we were unfortunate and we couldn't even hear him say one thing. And thank you very much to the participants, when I looked at it, I think we had close to 500 participants at the last gaze and the number of participants. You've made it all worthwhile. Thank you very much and have a good evening. I wish us good success as our conference proceeds towards the end. Thank you.
Thank you so much, Professor Ashenua, for that. Another very enlightening and interesting symposium, this time on the rule of law. We're now moving into the last two activities for today, and they're both training sessions. The first is on building a digitally fit business. And this will be facilitated by Olushola Adewale, partner at PricewaterhouseCoopers. He holds a master's in human resources management from the Fisher College of Business at the Ohio State University, Columbus, Ohio in the US, where he was until recently on the teaching faculty. In the last 24 years, Olushola has led successful organization effectiveness projects for leading African and multinational organizations across all major industries. He's a partner and territory leader of PwC's Global Digital Upskilling Initiative. That's the New World New Skills. He leads the firm's people and organization advisory practice in Nigeria, Ghana, and Liberia, with a focus on digital workforce transformation. And today he will be assisted by Samuel Akinlotan, management consultant at PwC. After that, we'll have another training session, the PCL COVID framework, managing employee well-being in times of uncertainty. This will be facilitated by Rob Taiwo, managing director of Philips Consulting. He has over 20 years international experience working extensively in leadership positions for the FTSE 100 companies and leading multinationals across the UK, Europe, and West Africa. His specialties include business strategy, corporate strategy, leadership development, transformation and change, operating model development, performance management, and cost benefits optimization. And he will be assisted today by Nwaji Jibuno. Thank you.
The chairman section on legal practice, and may I take a little bit of your time to inform you about one of the foremost publications we have in the field of legal practice in Nigeria, produced by the Nigerian Bar Association. And I'm speaking about the Nigerian Bar Association section on legal practice journal. This is both a professional and an academic publication of the section that speaks to various practice areas. The contributions and the papers that have been captured in these journals since inception have contributed immensely to the development of the law, to academic research, and to case management in firms, as well as the decisions of various superior courts. In this latest edition, which just came off the press last week in time for the NBA 2020 conference, we have articles that cover fields of criminal law, electoral law and practice, labor and employment law, telecommunications law, medical law, constitutional, administrative law, and several other fields. It's the 6th edition in the series. This is a duly accredited journal for academics, accredited journal and reference material, even for court advocates. I want to recommend this if you do not have it in your library. And you can also pick up the previous volumes from the MBA SLP Secretariat. You can place your order by calling Bonuade on 081 66 41 3698 081 66 41 3698. Or you can just send an email to info@mba-slp.org. info@mba-slp.org, and you can order a copy from the Secretariat. You can also discuss how they can ship it to you wherever you might be located. In view of the pandemic, this would have ordinarily been available to pick up at the conference venue, but being a virtual conference, you would have to place an order and it will be definitely shipped to you. I want to encourage everyone who is here not to miss this opportunity You can go away with this and you can continue to build your library and build the level of intellectual contributions we make to our judgments in court as well as to our academic papers. Thank you very much and have a wonderful conference.
Conference was going to happen at all, but we remained dogged.
Good day to all the highly esteemed dignitaries, learned self,
today,
my learned colleagues,
you're all
distinguished ladies and
to history.
gentlemen. My name is Fumi
I want to
Ayeni,
start
and I am the Executive Secretary
thank
of the Lagos Public Interest Law
first
Partnership.
by acknowledging our President of the Federal Republic of Nigeria, His Excellency President Muhammadu Buhari, GCFR.
This conference affords us the opportunity to review how we operate.
Partnered with the Nigerian Bar Association in different fora. I recall very vividly in 2018 that became
We should not toy with the independence of the judiciary.
With well over 12,000 delegates in this conference, this is by far the largest gathering of lawyers on the continent of Africa.
our very own fascinating.
Dear learned colleagues, as we overcome these trying times and settle down to a new normal, Law Pavilion celebrates the resilience of our esteemed clients. We have unveiled a new ecosystem of legal service delivery in Nigeria, so you can harness the silver lining of opportunities that lie within this crisis. Introducing the new Law Pavilion Prime 5.0, now available online for mobile phone users. Fortified with court forms from all jurisdictions with pre-filled sampled forms. AI-assisted document review system.
And this is just let me know when. Thank you. I also want to thank
Microsoft Word plugin that enhances your legal drafting advantage right within your Microsoft
Speaker
Word.
of the Federal House of Representatives, Right Honorable Femi Gbajabiamila.
Manage your law firm remotely with our case management system.
Being so true to his word.
One more thing, get access to millions of potential clients through our new industry-leading lawyers and law firms directory. Experience the new normal in legal service delivery today. Visit www.lawpavilion.com/experience.
Hello, it's that time of the year again.
And we at Solo and Co are here for you.
What's more interesting is you can order in several ways. You can come to one of our stores in Abuja, 40 Dublin Street, Wuse 2, or in Lagos at the Law School campus or at Landmark Tower. You can also go online www.solohan.com.ng and place your order there. There's a wide range of products. All our products are there. You can order from there or hit us a DM on Instagram or message us on WhatsApp.
When you order any of our products, we deliver to you within 2 to 4 working days. Or you can as well pick up at our head office in Abuja.
When you buy any of our products, we give you a complimentary photo shoot. We're saving you the time and the hassle of going helter-skelter trying to find a photographer. We have the best for you. Shop at Solohan.
Personally, he ensured that he was fully represented and actively participated in the 2 days. I want to thank Dr. Isa Ali Patti, Minister of Communications and Digital Economy. He jumped on him, was there for his last year, again this year. His Excellency Governor Yesam Wike,
Post-COVID-19, economies are being reset. And the true definition of wealth is now an intangible intellectual property. The required innovations for restarting the economy and governance rely on the maintenance of rule of law, through
give a
equal
good
and
account of
efficient
himself.
access to justice.
I'd like to also
Law Pavilion, in
thank
partnership with Telnet, presents
His
the following
Excellency, the
innovative
Governor of
solutions,
Lagos,
redefining
Governor
a new
Babajide
ecosystem
Sanwo-Olu,
for justice delivery in Nigeria. Law Rights. This is a mobile application that displaces the old practice of consulting family and friends first for legal advice by making all necessary information available anytime, anywhere. You don't only get to know your rights, you can easily report a violation or consult a lawyer in a jiffy, among other things. The Law Rights app, in conjunction with the Case Manager Assured, provides the lawyer advanced tools to properly manage his clients, briefs, tasks, and entire law firm. The Case Manager Assured integrates with the Law Pavilion Prime, an online repository of case laws, regulations, precedents, forms and agreements, and rules of court. This makes it possible to achieve so much in so little time. It is the reliable legal research companion. Now it also boasts of e-laws of Lagos State, as well as legal textbooks and journals. It's a complete e-library for today's lawyer. E-registry removes the stress involved in filing a matter in court registries, as this can now be done seamlessly from anywhere, anytime. Court Manager Assured automatically captures documents from the e-registry and helps judges monitor progress of matters from a single dashboard. Oh, one more thing. The Court Manager Assured uses artificial intelligence to help judges review lawyer submissions and documents, making administration of justice easier, faster, and much more efficient. Now that's the new ecosystem of legal service delivery.
Mr. Olawale Fakomunwa, Attorney General of Ekiti State, Judge
Visit
www.lawpavilion.com/experience. Former Vice President of the World Bank's Africa Division and co-founder Bring Back Our Girls, Mrs. Salamatu Husseina Suleiman, immediate past ECOWAS Commissioner for Political Affairs, Peace and Security, and former Minister of Women Affairs and Social Development. I'd also like to thank our keynote speaker, Mrs. Ibukun Awushika, the chairman of First Bank of Nigeria. She continues to do this nation proud in all her endeavors. I don't want to take for granted our anchors, Mrs. Mo Abudu of Ebony Light TV, who conducted the interview with Mr. Tony Blair. I would also like to thank Dr. Nduka Obadbena, chairman and editor-in-chief of This Day Media. Nduka, thank you very much. You have always been so supportive of everything we do. And I'd also like to thank Paula Hodges, QC, partner at Herbert Smith, Free Hills, Professor Kizu Mugai, former Attorney General of Kenya, Dr. Femi Elias, former UN Assistant General Secretary and visiting Professor of International Law, Queen Mary University of London. I want to thank, when we come back to our own, all the past presidents of the Nigerian Bar Association. Your stories were very rich. History is what defines the future. And you were there to let us know your time in office. And thank you for the time spent with us. I want to thank the section, especially section of business law, section on legal practice, and the section on special public interest, SPIDAL, for the programs you richly donated to this conference. As I mentioned in one of the sessions, the NBA feeds off its sections and fora. And when we plan conferences like this, they give us the content with which you see we serve you the rich menu that you all got during this conference. I want to thank the numerous bar associations globally who identified with us. I will have to give special word to our sponsors. Our headline sponsor, River State Government. And because, not just because His Excellency is a great very short notice, we go to him and he's there. He's doing it for the bar, he's doing it for other elements of the legal profession. Again, thank you very much. We thank all our friends, all our platinum sponsors. And in this regard, I thank in particular the prestigious Access Bank, that's rapidly becoming one of the largest banks indigenous to the continent of Africa. In particular, my good friend and brother, Dr. Herbert Higwe, the CEO, under whose direction the bank continues to grow from strength to strength. I want to thank our telecommunications partner, the MTN, everywhere you go. When I spoke to them about sponsorship, they did acknowledge the hard times. But they said for the NBA, we will do anything. They provided data which we freely distributed to the young participants that enabled them enjoy this conference. Thank you, MTN, and God bless you. We also like to thank the following law firms who have also shown big support to all.
My name is Olusegun Abimbola. I'm the chairman section of legal practice. May I take a little bit of your time to inform you about one of the foremost publications we have in the field of legal practice in Nigeria, produced by the Nigerian Bar Association. And I'm speaking about the Nigerian Bar Association section on legal practice journal. This is both a professional and an academic publication of the section that speaks to various practice areas. The contributions and the papers that have been captured in these journals since inception have contributed immensely to the development of the law, to academic research, and to case management in firms, as well as the decisions of various superior courts. In this latest edition, which just came off the press last week in time for the NBA 2020 conference, we have articles that cover fields of criminal law, electoral law and practice, labor and employment law, telecommunications law, medical law, constitutional administrative law, and several other fields. It's the 6th edition in the series. This is a duly accredited journal for academics, accredited journal and reference material, even for court advocates. I want to recommend this if you do not have it in your library. And you can also pick up the previous volumes from the NBA SLP Secretariat. You can place your order by calling Bono Ade on 081 66 41 3698 081 66413698, or you can just send an email to info@nba-slp.org, info@nba-slp.org, and you can order a copy from the Secretariat. You can also discuss how they can ship it to you wherever you might be located. In view of the pandemic, this would have ordinarily been available to pick up at the conference venue, but being a virtual conference, you would have to place an order and it will be definitely shipped to you. I want to encourage everyone who is here not to miss this opportunity. You can go away with this and you can continue to build your library and build the level of intellectual contributions we make to our judgments in court as well as to academic papers. Thank you very much and have a wonderful conference.
Work together with government to forge a partnership to make this country even greater than it is already. Finally, on behalf of the chairman of the TCCP, Professor Koinsola Ajayi.
This conference affords us the opportunity to review how we operate.
Take a bow. I know you can't do that, but all your efforts are so appreciated. You've been so wonderful. Had difficulties planning because we were all in uncharted.
We should not toy with the independence of the judiciary.
With well over 12,000 delegates in this conference, this is by far the largest gathering of lawyers on the continent of Africa.
I also want to thank
Dear learned colleagues, as we overcome these trying times and settle down to a new normal, Law Pavilion celebrates the resilience of our esteemed clients. We have unveiled a new ecosystem of legal service delivery in Nigeria, so you can harness the silver lining of opportunity that lie within this crisis. Introducing the new Law Pavilion Prime 5.0, now available online for mobile phone users, fortified with court forms from all jurisdictions with pre-filled sampled forms, AI-assisted document review system, Microsoft Word plugin that enhances your legal drafting advantage right within your Microsoft Word. Manage your law firm remotely with our case management system. One more thing, get access to millions of potential clients through our new industry-leading lawyers and law firms directory. Experience the new normal in legal service delivery today. Visit www.lawpavilion.com/experience.
Hello, it's that time of the year again.
And we at Solo One & Co are here for you.
What's more interesting is you can order in several ways. You can come to one of our stores in Abuja, 40 Dublin Street, Wuse 2, or in Lagos at the Law School campus or at Landmark Tower. You can also go online www.solohan.com.ng and place your order there. There's a wide range of products. All our products are there. You can order from there or hit us a DM on Instagram or message us on WhatsApp.
When you order any of our products, we deliver to you within 2 to 4 working days. Or you can as well pick up at our head office in Abuja.
When you buy any of our products, we give you a complimentary photo shoot. We're saving you the time and the hassle of going helter-skelter trying to find a photographer. We have the best for you. Shop at Solohan.
Post-COVID-19, economies are being reset. And the true definition of wealth is now an intangible intellectual property. The required innovations for restarting the economy and governance.
I would like to congratulate the Nigerian Bar Association, especially the president, Mr. Paul Usoro, SAN, on this very auspicious occasion of the 60th anniversary conference of our great association. The Nigerian Bar Association has a rich history of conferencing, and it is quite instructive that this year's conference is falling at a time we have the global pandemic, so it's going to be virtual, which is also another first in our history. But we have all decided that it should not dampen the enthusiasm with which we have celebrated our conferences. Our conferences are a convergence of all aspects and all facets of the legal profession, from our judges to our lawyers to those who are in industry. We converge in conviviality, in friendship, in networking, to ensure that we truly get to know one another better, and we truly get to live with the reality that the NBA has been a unifying force for all Nigerian lawyers. So on this very momentous occasion, I am really proud to be part of it, and I thank God that I'm alive to say it, and it's really phenomenal that we'll be celebrating 60 years of conferencing, which means we've churned out massive, massive numbers of well-groomed and really useful professionals. We've donated them, as it were, not just to this country, but to the entire world.
It gives me great pleasure to give this message to our association on the 60th anniversary. So I've been told, but I have my own correction on that. I think we've come a long way, and at the same time, we've made great strides. Some things we've done very well and we've improved. Some things we have scored below pass mark. But then, that is life. You know, you expect up and down. This new executive, I hope they will bring us upstream to be where we should be at this time in creation, because now is the time of the youth. So I can only wish them the very best of luck and hope they will build on the good lessons of the past. For the annual conference about to commence, I wish everybody good deliberation and a happy time.
Good day, ladies and gentlemen. My name is Avril Eyewedera. I am a forensic professional here in Lagos, Nigeria. Today, I'll be speaking on the topic forensic science and the legal system, the key to an effective criminal litigation. Forensic science, I'm sure you've seen CSI Miami and all those things, but forensic science is simply put as the application of science to law. So that means the law would work better using forensic science to aid and to build a case. Forensic science can be used for different applications. For example, in a case that involves the application of forensic science, the following questions can be answered. Why a crime was committed? Forensic psychologists and psychiatrists can help the courts understand if the defendant suffers from, for example, a mental illness or a psychological trauma that made them commit an offense based on forensic assessment. Another question forensic science can help answer is who committed a crime? Using DNA technology, which is unique because apart from identical twins, no two people share the same DNA, and fingerprints, which is even more sensitive because no two people share the same fingerprint. You can help identify a suspect in a crime and place them at a crime scene. When a crime occurred, you want to know when. Forensic pathologists and anthropologists can help the court determine approximate time of death to place a suspect in a scene and compare it with the suspect's alibi, that is statement of their location during the time of the incident. It can also help to answer what happened. If you watch the trial of the South African Blade Runner, Oscar Pistorius, you would see how forensic scientists reconstructed the crime scene in the courtroom to help the court understand how the crime was committed, to dispute the defendant's claim and give the court a first-hand glimpse of what occurred during the crime based on evidence collected from the crime scene. 5. We can also understand when a crime occurred. You can determine, for example, in a drowning case, is it truly drowning or possible homicide? By conducting an autopsy to check for signs of drowning, such as deposit of water in the lungs, diatoms and debris. You know, when someone has drowned in the water when they were alive, you would find all this in the lungs. But when they were dead, before they were put into the water, you most likely not find anything in the lung because they were not breathing in. There was no breathing process. So this can help the court understand if this is homicide or an accident. Then finally, how a crime occurred. Forensic ballistics, for example, can help the court understand that a death involving a gun is self-inflicted or a murder based on analysis such as gunshot residue analysis. Forensic science covers a lot of areas such as document analysis, DNA analysis, fingerprint analysis, cyber forensics, pathology, psychology, biology, and more that can help the court determine the guilty party. Not only that though, it can also help to exonerate the innocent. That is why one of the most important crime-fighting tools available to the criminal justice system is forensic science. Forensic science includes the business of providing timely, accurate, and thorough information to all levels of decision makers in the criminal justice system. Now, let's look at some interesting aspects of how forensic science can change the narrative in a criminal case. So, for example, in a case where asphyxia is caused by smoke inhalation, a pathologist can find signs of soot blackening in the lungs, and if the air containing the smoke was sufficiently hot, the lungs will also show signs of bone trauma. Because arson is sometimes, disguised as homicide, finding a dead body in a burning building and not finding signs of smoke in the lung is a red flag for possible death by homicide. You see how the narrative changed the moment forensic science was introduced. For example, in a sexual assault case, which is also very popular here in Nigeria, you will be able to match DNA from biological fluids and other evidence such as semen, blood, fingernail clippings found at the scene to a suspect at hand, mainly because we don't have a national DNA database that I'm aware of in Nigeria to prove that the person had a sexual relations with the victim. So you're linking the DNA or evidence found on the victim to a possible suspect. So it helps to reduce the likelihood of, the likelihood of accusing someone else of committing this crime. So in the case I handled for a company on behalf of the police a few years ago, where they had a break-in and some assets were stolen, I was able to lift fingerprints from the scene, which matched two people who later confessed because the evidence was overwhelming. Not only did it help the court move fast with the case, it made the process easy because it was clear. It was clear. Science. Science had all the answer. I've had experience in death investigation, document analysis, fingerprint analysis, and fire investigation using forensic science. And this just basically helps the police and courts build up cases that would be hard to deny based on evidence linking people to a scene. A good investigation will lead to a quicker trial as the judge, the lawyers, prosecutors do not need to dwell on circumstantial or hearsay evidences to build up or deliberate on the case. Forensic science holds the key to an effective investigation, which will later lead to an effective litigation. It is important for the judiciary, lawyers, magistrates, the judges to be trained and understand the concept of forensic science, crime scene investigation, how it works, how to cross-examine a forensic expert witness, which is critical in a criminal case, especially for a defense lawyer to ensure an effective litigation process. It will also help for better standards for the practice of forensic science in Nigeria if the courts have to scrutinize the evidence. An effective criminal litigation process would work with the principle in which forensic science is based on. Every contact leaves a trace. So that means every time you come in contact with someone or a place, you leave a bit of yourself there and you take a bit of the place with you or the person with you, which would help the court understand that there's been an interaction. We're still behind with forensic science in Nigeria, but together, the police, the judiciary, and the forensic scientists can work together to make this work. If the judiciary embraced forensic science, the law enforcement agencies would have no choice but to also embrace it. And together we can create a country that works with the law, that effectively prepare a criminal case that is beyond a reasonable doubt. Thank you to the organizers of the MBA conference for this opportunity, and I'm so happy that I've been able to share a bit of what I do with you. And please enjoy the rest of the conference and stay safe. Thank you.
My name is Bisi Fayemi. I am a women's rights activist, gender specialist, policy advocate, and writer. I bring you warm greetings from Ekiti State, the land of honor, where I'm the First Lady
I welcome all conferees to the 60th Annual General Conference of the Nigerian Bar Association, our great and noble association. It is our first virtual conference, and I know it will be different on many fronts and in many regards.
Well, this is a very tough question, but I think that in the context of the development of the association over the years, perhaps one of the biggest challenges we faced was when we had the crisis back in 1992. And the profession faced its biggest crisis of confidence. Membership of the association was polarized along very divisive lines. And, you know, it brought the association to disrepute across the country. But I think what was significant was the way the association and its members were able to rise to the occasion. And in spite of all the delays and long period of acrimony, we're still able to come together and sort of rebuild the association at its institutions and arrive at some sort of compromise that allowed us to rise above those challenges. I think that sent a very strong message, you know, not only to the membership, but I think also to Nigerians in general, that this country you know, is much better, much stronger when we're united and when we act together, and that we can really face our differences and really resolve issues. So obviously, I was at that time a young lawyer. I was, I think, chairman of, at one point, chairman of the Kano branch. And I have to commend people like Chief Awomolo, people like Mr. Poko, SAN, and others, you know, who all came together, you know, to really sort of pull all the various strings, you know, of disparate sort of, you know, views and interests, and then bring everybody together and rise above those challenges. So I think that for me was a very, very important, you know, experience for the association, and it sent a very, you know, strong message across the country. Now, talking about another milestone,